Life and history of Justice Scalia. I'll talk a little bit after him about the consequences of his death. I think then that's going to be followed by Professor Priester, who will talk about some of the criminal due process cases. And that will be followed, I believe, by Professors Pingree, Hopkins, and McLaughlin, talking on a related number of privacy and family law and fundamental rights types issues. And then Professor Schmidt will round it all out with something really eloquent and wonderful. I'm not sure what yet, right? But he'll figure it out by the time we get there. And we're hoping to limit our talks to probably 5 to 10 minutes, so that hopefully at the end there'll be plenty of time for you to ask us questions and for there to be some interaction between all of us. With that said, I'll give you Professor Cullen.
Good morning. Saturday night, I was at my granddaughter's birthday party when one of my students sent me an email saying, "Hey, did you see this about Justice Scalia?" I had not. But when I went to the website after I confirmed it wasn't a scam, I could say safely that I felt like my heart was ripped out of my chest at the idea that Justice Antonin Scalia was dead, especially at this time of history, in the middle of a presidential election year, because you're going to hear from several of us today, and you're going to probably see that Justice Scalia was a polarizing figure. Some of you may know him and hate him, and some of you may know him and love him. I don't know if any of you are just sort of in the middle when it comes to Justice Scalia. But I think wherever we stand on Justice Scalia, hopefully we will all agree that he was one of the great, if not the greatest, Supreme Court justice of this generation. Dare I say of all time. I don't know if that would be going too far. But I want to tell you just a little bit about Justice Scalia. Let me see if these slides are going to flip with this thing. Yes. Whoa.
No, that's my slides.
How did that happen? Just Professor Schmidt's already sabotaging my talk. All right, how about that? Notice how he made it look exactly like mine. All right. Yes. Justice Scalia. What about Justice Scalia? He was born in New Jersey, the son of an immigrant Italian family. Born in Trenton in 1936, moved to Queens, New York. I wore my New York tie for Justice Scalia today, for all of you. His immigrant father, Eugene Scalia, taught Romance languages at Brooklyn College. His mother, Catherine, was a school teacher. There's him. He was raised Catholic, not surprisingly, with that heritage. And he went to, you can see some pictures of him at an all-boys school, Jesuit school in Manhattan, Xavier High School, kind of a military Catholic prep school, if you will. He also was into arts, music, he sang, he was a real character. They called him Nino, and that name stuck with him throughout his whole life. Scalia the student, hopefully that's up there right now. At Georgetown University, he graduated first in his class, went on to Harvard Law School, graduated magna cum laude, was the editor of the Law Review, and even at that stage of his life was recognized as an up-and-coming great scholar. Scalia the professional. After law school, he wound up taking a few law professor jobs. He taught at the University of Virginia, Professor Schmidt's alma mater, from 1967 to 71. He taught at the University of Chicago from 1977 to 82. He was a visiting professor at Georgetown and Stanford. He also had stints working in President Nixon's White House and in President Ford's Department of Justice. So he had a background as a professional. Scalia the judge. President Reagan in 1982 appointed him to the U.S. Court of Appeals for the District of Columbia Circuit, where he served for 4 years. And then you can see President Reagan nominating him to a vacancy on the U.S. Supreme Court. And in fact, he was confirmed unanimously by the Senate. And this is what Senator Edward Kennedy had to say about Justice Scalia when he cast his vote in favor of him. Justice Kennedy, perhaps being the most liberal member of the Senate at that time, he said Scalia was clearly in the mainstream of thought of our society, and that he was someone who has demonstrated a brilliant legal intellect and earned the respect, even the affection, of colleagues whose personal philosophies are far different from his own. So again, I mean, whether you hate him or love him, people recognized on both sides of the aisle that he was a great choice for the Supreme Court. Scalia the father and the friend. As a devout Catholic, he had 9 kids. One of his kids became a priest. He has 36 grandchildren. His wife Maureen and him met on a blind date while at Harvard. You see him there with Justice Ginsburg in opera costume. He actually could sing opera. He actually once appeared in the opera in a costume worn by Placido Domingo. So, love of music. And then what I would say is obviously the greatest contribution of Justice Scalia is Justice Scalia, the visionary Supreme Court justice and leader. I don't think I can overstate Justice Scalia's importance to the conservative movement, to originalism. He wasn't part of a movement. He was the movement. It's rare, I think, that you would see somebody with the qualities of his personality, his very strong, assertive personality, witty, likable, combined with a vision of where he thought the court should go with regard to originalism and textual interpretation of the Constitution and statutes, with regard to having the ability to influence his fellow justices, to sometimes reverse major areas. You're going to hear from Professor Priester about some of the Fourth Amendment, Sixth Amendment changes that he brought to the court, that he was a leader on. And again, somebody who could write with that kind of clarity and wittiness, and nobody remembers most people's opinions, but everybody remembers Scalia's opinions. And there's a reason for that. So it's rare to have all of that in one guy, and that's why I think he stands as a giant. And yeah, even the other justices that are on the Supreme Court right now, the other conservative justices, it's hard to see any of them stepping into his shoes and being the kind of leader that they lost here. So it's a big deal, right, who they're going to fill his slot. So somebody else will talk about that. As a tribute to maybe the, what does Scalia do to the court? Professor Michael Dorff noted, Scalia is at the heart of a major shift on the court in how cases are presented, how legislative history is understood. We used to start with history and thinking about interpreting the law, but now, thanks to Justice Scalia, we start with the language of the Constitution or the law. And Ronald Dworkin, very liberal professor, noted, we're all originalists now, after Justice Scalia. So with that, I wrote a law review article called Mr. Scalia's Neighborhood in 2007. It looked at his Establishment Clause jurisprudence and what would the world be like for especially minority religions if we lived in a world ruled by Justice Scalia's Establishment Clause jurisprudence. So anyway, that's all the time I have to say. I just want to set up, before these guys start knocking Justice Scalia down, hopefully we'll all recognize that he was a giant, and I think you'll see when you start hearing the breadth of impact he had in so many different areas that this is true and that this is a great loss to the country, no matter how you feel about him. The last thing I want to say about him is that Justice Scalia, as a devout Catholic, had very strongly held religious beliefs. He was against abortion, he was for natural law, and other things like that. But if you listen to him as a jurist, he gave plenty of speeches where he said, I don't think the Constitution has anything to do with abortion. And in fact, the states could pass abortion on demand, and I wouldn't do anything about it from the Supreme Court because the Constitution doesn't say anything about it. So no matter how strongly he felt about an issue like that, personally, he wasn't going to let his principled philosophy about originalism interfere with that. And I think that speaks loads for the kind of principled jurist that he was. So I will turn it over, I believe, to Professor Roeder next.
first of all, for those in the back, you can sit up here, and there's a lot of seats in the front row here on the safe side of the podium. And there's also chairs up here if anyone wants to come up and grab them, so you don't have to. This isn't meant to be a super formal, although we're dressed more formally than some. But you shouldn't feel shy. Come on up. Okay, so Professor Colling talked about the life of Justice Scalia, and I'm going to talk about the ramifications of his death. Right? You probably, most of you know who know me, don't know that I don't agree with most of Justice Scalia's opinions. And that's not to say I don't think he was a great man, but I'm not sure that he left the world a much better place because of his jurisprudence, maybe in some areas, but maybe not in others. But what he definitely left was a huge gap on an otherwise majority conservative court that largely followed his views, right? Now, the thing you have up on there is not the best illustration because I wouldn't necessarily have them in that order, right? Kennedy should be in the place where Scalia is, and other people, he should be down further on the right. So Kennedy sometimes swings both ways, left or to the right, depending on the case. But with Scalia gone, it's very clear, and it's all over the media, that there's a big gap now. And a lot of those decisions that went 5-4 in a conservative direction are now very vulnerable for going in the other direction, right? Now, you might ask, in a Scalia fashion, what would the founders have done if there was a gap in the court in a, election year, the end of the president's term? And I think George Washington would have said, I'm nominating somebody, because he did, right? And I don't think Adams did, but I think Thomas Jefferson did. And so have multitudes of presidents since the time of the founding, right? So there's nothing in the Constitution to stop President Obama from nominating somebody. Now, whether that person will make it through or not, it's doubtful, right? But there's plenty of precedent for that nomination process to happen. Now, because of our current situation, which is 4 justices who are relatively conservative remaining and 4 justices that are liberal, you have the potential for a lot of deadlocks on the current docket, right? And there's President Obama's executive action, there's the Texas abortion case, there's Obama's administrative rules on immigration, there's the public sector unions case, there's redistricting, that is voting rights cases, there's affirmative action at universities, and there's Obama's Clean Power Plan. All of these things are before the court now. And 4-4 decisions is going to mean that the lower court's decision will stand, or they'll set these things for rehearing, and they'll remain in limbo until someone is appointed, right? And so I put up some of the possible consequences of this 4-4, stalemate. In some cases, it means that a left-leaning decision below will stand. In some cases, it may mean a right-leaning decision below will stand. There's no doubt that a liberal justice replacing him, or even letting it as it stands, is going to possibly change the legal terrain of our constitutional jurisprudence, right? So in addition to these cases that could go one way or another now, that balance has been realigned to a liberal balance, right? It's been a conservative balance for the last 20 years or more, maybe 25 years. And that's maybe why Scalia has been so important for the last 25 years. He's had a majority, in some cases a supermajority, of Republican appointees with him. Now, in addition to those cases that are on the docket now that may come out in somewhat unpredictable ways, there's a whole bunch of other cases that have been decided over the last 5 to 6 years that could be reversed, right? So if you're in con law, you know Most of those major cases that we seem to be getting the last 5-10 years all seem to be 5-4 decisions, right? And so of those, Citizens United, I hope that one gets reversed. McDonald v. Chicago, your gun rights in states, that could be reversed. Walmart v. Dukes, which is actually a class action case, right? Not a common law case. But the Supreme Court 5-4 said that female employees could not certify as a class to bring gender discrimination claims against Walmart. That could be reversed. Shelby County v. Holder, striking down part of the Voting Rights Amendment. That could arguably be reversed. Amnesty International v. Clapper, where the court said we're not going to hear these cases on NRA spying because the lawyers who are being spied on don't have standing. Hopefully that could be reversed. Burwell v. Hobby Lobby, which is in some ways like Citizens United, in finding that corporations are people too, could also be vulnerable and be reversed, right? Now you may or may not love a lot of these decisions. I don't like any of them, right? So I'm somewhat happy about the possibility that they may be changed, right? If you're conservative, you're probably definitely not happy about the possibility that they could be changed. And so it's very clear how important this election year is, how much this next appointment's going to be. And so we'll see what happens. At the very least, I'm very thankful for Scalia for making constitutional law very interesting and maybe exceedingly more interesting in his death, in some cases than in his life. But if we get to question time and you have any questions about any of those cases from before or any of the cases that are coming up, I'd be happy to answer questions. That's it. I'll turn it over to Professor Priestley.
All right. There we go. So, obviously I'm going to talk about crim law, crim pro, rather than sort of straight up comp law that everyone else is talking about. But before I do that, I want to make one other point tying into the politics of it. Just because I think it's context that a lot of people don't always think about in the presidential election generally or in Supreme Court. So going back about 100 years, 1932, when FDR is elected president after the Great Depression. From 1932 to 1968, 36 years, the Democrats won 7 of the 9 presidential elections. 2 terms of Eisenhower in the 50s, but for that 36-year period, the Democrats were president basically the whole time and appointed all the justices. 1968, when Nixon wins, 1968 to 1992, 24-year period, Republicans won 6 out of 7 presidential elections. Now, since 1992, when Bill Clinton was elected, the Democrats have won 4 out of 6. And if a Democratic candidate wins the next election and gets reelected, right, it'll be 6 out of 8, which is roughly comparable to the 6 out of 7 in the previous block, right? So we see these shifts in the court, we see these shifts in politics. This is why conservatives now, I think, are feeling like, whoa, things are changing. Whoa, why are things changing? Well, it's if the pendulum is swinging, and we're going from a 6-1 in one direction to a 6-2 in the other direction, it does feel that. They're feeling the same way the Democrats felt in the 60s and 70s, right? When they were losing all the elections and what's going on, right? Oh my God, Nixon's appointing all these conservative justices, this is terrible, right? It's exactly the same dynamic, just swinging back and forth. So, Scalia is an interesting figure because obviously he's very conservative, and I think Professor Cohen was exactly right. One of the most influential justices, certainly of anyone's lifetime in this room. And his philosophy influenced a lot of different areas. But one thing I'm sure we'll talk quite a bit about is he's a big fan of the Constitution and the text and enumerated rights. Not really a big fan of unenumerated rights, rights that aren't in the text. So, crim pro. For him, the death penalty cases are really easy, right? Because the Constitution says no person shall be deprived of life, liberty, or property without due process of law. So the Constitution says you can be deprived of life at the end, right? I mean, if you're a textualist, it's right there. You can be deprived. Now, what's due process of law? But it says you can be deprived of life. So the death penalty's right there. The Eighth Amendment says no cruel and unusual punishments. And it's a very easy answer for him. He says, well, look, in 1791, the death penalty was authorized. Therefore, by definition, it couldn't have been cruel and unusual in 1791. Full stop. Now, a lot of other justices on the court, including Kennedy and O'Connor and some of the others, said, no, the meaning of the Constitution can evolve. And in the Eighth Amendment context, the standard they use is the evolving standards of decency, which is what they've used to strike down execution of juveniles, execution of people with mental disabilities, things like that. And Scalia has dissented in all those cases, saying, whoops, that's not consistent with originalism. And their response is, that's fine, we're not originalists. So, right? I mean, if you don't accept that originalism is the mandated way of interpreting the Constitution, then that's not a persuasive argument, or at least not a conclusive argument. So the death penalty cases are really easy for him. Exclusionary rule, where we throw out evidence that's obtained in violation of the Fourth Amendment or the Fifth Amendment. He's not a big fan of that because it benefits criminals. But and what he's never had to confront, because the Supreme Court never took an issue that specifically addressed, are we going to throw out the exclusionary rule, is the text of the Constitution doesn't mandate any remedy. Right? It just says unreasonable searches and seizures are prohibited. So but there has to be a remedy, because otherwise the right is worthless. So the court would have to create some remedy because there isn't one specified. So then you could, now he as an originalist, you would look back and say, what do the framers think the remedy would be? Things like that. So it's not clear. He never had to actually advocate for what he thought the alternative to the exclusionary rule is, right? And as lawyers, we all know it's much easier to pot-shot something else than actually have your own proposal, right? So he took a lot of shots at the exclusionary rule for 30 years, but he never had to justify, well, here's what we should do instead, right? So it's interesting dynamic. Another one that we all love, Miranda versus Arizona, getting read your rights before you're interrogated by the police. He wrote the lead dissent in a case called U.S. versus Dickerson in 2000, which is the case where the Supreme Court explicitly granted cert to decide whether they're going to overrule Miranda. And it went 7-2. No, we're not going to overrule Miranda. But he dissented, and he said, this is all made up. It's all made up. The Constitution doesn't require it. The self-incrimination clause doesn't require it. It's all made up, and I don't like it. And the rest of the justices said, no, we do. Sorry. So, he has these places where he thinks the court is creating rights that aren't in the text or don't follow from the text. He's been very critical of them. But when there are rights that are in the text that he can point to originalist sources on, then he enforces them very powerfully. And what we see in Crim Pro is, the way I think about it is this way. In many ways today, our society has become less concerned about civil liberties and government overreaching than the founders were, right? I mean, the 1776 Declaration of Independence is basically one big blog post grievance list, right? Here's the following things that King George did are terrible. And it's a big list of things, and they're all in the, most of them, a lot of them are in the Bill of Rights, right? Jury trials, venue of the jury at the location where the crime was committed, no censorship of the press, no censorship of free speech, protection of religious freedom, all these sorts of things. No unreasonable searches and seizures. They're in the Constitution. So Justice Scalia then says, well, look, these rights are there. And the history limits them. So we have the thermal imager case, where he says you can't use a thermal imager to scan a home, to see the heat signatures in the home, because at the time of the founding, you could have only figured that out if you went in the home. And you can't go in the home without a warrant, so you can't use X-ray vision to go in the home without a warrant. Or you can't attach a GPS device to somebody's car and follow them around with it because you're trespassing on their car, and the common law cared a lot about trespass. One of my favorite dissents of his was the case Maryland versus King, which is about DNA swabs taken from people who are arrested. Not convicted, because convicted is a little more challenging, right? But who's been arrested for a crime based on probable cause. And he dissented, and the majority allowed it. They said if you've got a person who's been arrested, you can DNA swab them out for identification purposes. And Justice Scalia writes, today's judgment will, to be sure, have the beneficial effect of solving more crimes. Then again, so would taking the DNA samples from anyone who flies on an airplane, applies for a driver's license, or attends a public school. Perhaps the construction of such a genetic panopticon is wise, but I doubt that the proud men who wrote the Charter of Our Liberties would have been so eager to open their mouths for royal inspection. That's the originalist perspective, right? That, no, wait a second. I mean, obviously the founders didn't know anything about DNA, but they wouldn't have been okay with this. Another area, aside from the Fourth Amendment, that Justice Scalia has been particularly powerful is the Sixth Amendment. Two areas, if you've taken evidence, confrontation clause. Crawford v. Washington and the related precedents on that, none of that existed prior to Justice Scalia starting some dissents in the late 80s that ultimately ripened a decade later into these confrontation clause opinions. And I don't have a good quote necessarily from those opinions, but the idea was the majority of the court had really said, well, look, as long as the evidence is reliable, it can be admitted. And he says, no. The whole point of the confrontation clause is the way you determine whether testimony is reliable is you cross-examine it. If it hasn't been cross-examined, you don't know if it's reliable. You're substituting the goal for the process. And he won that argument and converted people around. And then, of course, some of the subsequent decisions interpreting Crawford went against him, and he started dissenting from the application of his own rule because he said, no, that's not what I meant. Right? So the court doesn't, they just don't always agree fully on what he wants. Another area is jury trial right in the Sixth Amendment. There was a case in 1999 where the Supreme Court upheld a conviction on harmless error, where the jury instructions on the elements of the offense were wrong. And the majority said, well, look, if the jury had been instructed right, they would have reached the same result, so we don't really care. And he wrote a very strident dissent saying, no, you can't substitute the judgment of the appeals court for what the jury didn't actually decide. But he only had 4 votes. Another area in the Sixth Amendment is the jury trial is sentencing. Prior to a line of cases that started in 2000, judges were allowed to use the federal sentencing guidelines and all sorts of other rules in imposing sentence. And Justice Scalia says, no, these sentencing rules are tantamount to convicting of an aggravated offense. It's equivalent of convicting you of aggravated battery when really you were only charged with simple battery. And he got the votes for that. And barely, but he got them. And one of my other favorite quotes is from one of these cases called Ring versus Arizona, which is actually a death penalty case that was the basis for the Hearst decision that overturned the Florida death penalty a couple of weeks ago. You might have heard about that in the news. So Justice Breyer had dissented initially and then flipped around in Ring. And Justice Scalia writes, while I am, as always, pleased to travel in Justice Breyer's company, the unfortunate fact is that today's judgment has nothing to do with jury sentencing. Right? It's not about jury sentencing. It's about the elements of the crime. There is really no way in which Justice Breyer can travel with the happy band that reaches today's result unless he says yes to Apprendi, which is the name. Concisely put, Justice Breyer is on the wrong flight. He should either get off before the doors close or buy a ticket to Apprendi Lane. And I actually use that as in the title of one of my law review articles. I'm using the phrase Apprendi Lane because it cracks me up. So in con law, we see a very consistent pattern with the rest of his jurisprudence, which is enumerated rights he's going to interpret based on what he thinks the framers had in mind in 1791, and on unenumerated rights, he doesn't like them. One other point on statutory interpretation, obviously he had a big impact there too, focusing on textualism. And one of the areas of textualism where he reinvigorated some of the law from previously is an avoid for vagueness doctrine, which has not really had a lot of teeth for a long time. But in the last couple of years, maybe 10 years really, the Supreme Court has thrown out 2 really significant federal statutes on void for vagueness. One is a statute called the Armed Career Criminal Act that imposes enhanced sentences for armed career criminals. Exactly what it sounds like, recidivists who have weapons. And there was a residual clause in that statute that basically said, well, any dangerous felony. He said, there's no limit there. We don't know what that means. And he dissented and finally got the votes last year to throw it out. And about 5 years ago before that, the Skilling case, which arose out of the Enron scandal, was challenging a statute called the Honest Services Mail Fraud. And he had been dissenting for a long time in that area too, saying we don't have any idea what the statute means. And he finally got a majority of the court to throw out that statute. Although he ended up concurring because Justice Ginsburg's opinion didn't go quite as far as he wanted to. He said, well, you're trying to save the statute. We should strike the whole thing down. He didn't get quite the votes for that. But it was a void for vagueness analysis that he was putting forward. So he's a textualist, but at the same time, you got to write the text that's actually meaning, or it's worthless. So it's really interesting because even though he's obviously well-known conservative justice, he's written a whole bunch of crim pro opinions where the defendant wins. And they always come from that core of the originalist interpretation of the framers cared more about jury trials than we do today. Right? The framers cared more about unreachable search and seizures than we do today. And so he's going to push back on that. And sometimes that benefits the defendant. In other areas, it doesn't. So that's what I've got to say.